or may.
ছশো বাইশ থেকে ছিল লিস্টে দিতে হবে, যদি কেউ চার্জে থাকে তাহলে ওখানে মেনশন করবো। লিস্টটা দেখো যে কোনগুলো রান করছে, পুরোনো লিস্টটা সেগুলোকেই রাখো না। ওগুলো 450 কেন তুলে দেবে? বসাতে কত তুলে দেখো, আগে দেখে নাও ওখানে কতগুলো আছে, কি আছে লিস্টে। কেবল 650 রেকর্ডই নিয়ে বসেছি না তো, হবে মান্থলি লিস্টে ছিল, মান্থলি লিস্টে রেখে দিতে পারি। পুরোনো লিস্টটা দেখে নাও, লিস্টে থাকে তাহলে লিস্টের বাইরে করার দরকার নেই। Yes.
Or may I permit to mention in the probate matter, my lord, your lordship was pleased to pass an order on 19 July.
30.
Mal.
Come on 12.
Mal.
Any mentioning? Item number 1.
This is my restoration application. 1, 2, and 3 both, all are restoration applications. But your lordship had the occasion to consider a similar matter considering a same plot of land of the same family members. My lord, on day before yesterday, which your lordship was kind enough to
Ghosh.
allow.
Yes.
Rupak Ghosh was assisting your lordship. My lord. Order has possibly not yet been uploaded, but nonetheless, my lord, your lordship was pleased to allow. My lord, only thing here is, my lord, technically there is a delay of, my lord, over 9 years. But we have shown, my lord, sufficient cause which prevented us. But if your lordship kindly takes a look at, but before taking your lordship to the execution to the restoration application, only in 2 minutes, the facts in a nutshell, my lord. So the property at, my lord, Rajarhat, my lord, is the subject matter. But there was a section 4 notice under the Land Acquisition Act, and there was a declaration under section 6 of the Land Acquisition Act. But thereafter, all these we came to learn, as in the original writ petitioner, who is no more, came to learn from a newspaper. And they immediately filed, my lord, the writ petition challenging the notices. Well, in the writ petition, initially, when this honorable court had the occasion to take up the matter, well, by an order specifically directed the respondent authorities to file affidavits. No affidavits have been filed. Well, thereafter, the matter was dismissed for default. Well, in the interregnum, what had happened was, well, the petitioner had passed away. Right? And this restoration application is being taken out by his legal heirs. Right? And he was the whole and soul in the family who used to look after all land matters, all proceedings, all court proceedings, everything. So the present members of the family, they were completely unaware of this. But they wanted to sell the land because they knew this is their land. They wanted to sell the land. The broker who carried out due diligence found that there is an invitation to offer or a letter of intent published by an authority for selling the land. It is thereafter that, my lord, they have come running to court indicating, my lord, that, my lord, we find thereafter cause searches and found there is a writ petition, and we are seeking to have it restored. But in the restoration application, apart from, my lord, all these grounds, my lord, we have shown documents of medical documents to show that how he was suffering, he was hospitalized, and death certificate, and how he ultimately succumbed to his illness in 2018. But in the reply, my lord, my learned senior friend's client had taken contention that the land has been, my lord, acquired and possession has been taken and award has been passed. My lord, no averment has been there and no proof has been given as to payment of the award. But that is on the merits. My lord, your lordship will consider from the restoration point of view, my lord, if I may humbly beseech your lordship to kindly take a look at the restoration application. But if your lordship kindly takes a look at paragraph 2 first, in very brief, my lord, I'll indicate in paragraph 2, my lord, the other writ petitions also, one of which your lordship had the, my lord, occasion to consider day before yesterday. And grounds taken by in the affidavit in opposition are identical. Apart from the fact, the only difference is there it was around possibly 1 year old. Section 5. 1 year old. Here the period is much more. And we have filed a separate section 5 application. But these are the details of the writ petitions given. I'm not troubling your lordship with that. Then kindly, my lord, straight away takes a look at paragraph 10 onwards. I would humbly beseech, my lord, that I would place 2-3 paragraphs in detail, because this is where I have pleaded what prevented me and what is the sufficient cause which prevented. At all material times, the present writ petition and the other writ petitions were being handled by the writ petitioner number 1, Rajkumar Sarao. The writ petitioner number 2 is Sushila Saraugi, the widow of Rajkumar Sarao. The writ petition number 3, Ashok Tibrewal, is the nephew, sister son of the writ petition number 1, and the writ petition 4 is the wife of Ashok Tibrewal. Rajkumar Saraugi, the original petition number 1, suddenly died on 14 November 2018 at a relatively young age of 58 years. Copy of the death certificate is annexed. Before that, he was extremely unwell with chronic heart disease, diabetes, and hypertension since around 2015. A copy of the medical bill in this regard is annexed to this. Your lordship will find at page 96. He was admitted to Bridge Candy Hospital in Mumbai. Apart from the present writ petition, the original petition number 1 was handling all other writ petitions and had personally affirmed several other writ petitions. In fact, in his life, the original petition number 1 had handled all legal issues for the family, as also one Salasa Stockbroking Limited, member of NSE BSE, in which the original petitioner number 1 and his brother are the principal shareholders, directors, and persons in control. When Rajkumar Saraugi died on 14 November 2018, the petitioner number 2 and his wife was completely heartbroken. The petitioner numbers 3 and 4 had never personally handled the writ petition, or for that matter, any other legal cases. He had acquired a share in DAG number 4449 as a pure investment, and only because his uncle Rajkumar Saraugi, the original petitioner number 1, and Pradeep Kumar Saraugi and the other family members were acquiring the said DAG number 4449 and other DAG numbers mentioned above. The petitioner number 234 had never had any occasion to personally interact with Mr. Obijit Chokar. This part, as stated above, was being handled exclusively by late Rajkumar Saraugi. Representatives of the petitioners would visit the premises such and such, and the feedback was always the same. The DAG number such and such is lying unbarren and unencroached. Apropos this, only one document which I shall show at page 88, and then I'll humbly beseech your lordship to kindly once again consider the pleadings. Kindly sees page 88. This is a download from banglarbhumi.com, which is with regard to the record of rights of lands in Bengal. Kindly sees the date 11th May 2024 at 11:06 in the morning.
Yes.
But your lordship will see just below that the DAG number is mentioned 4449. Then kindly sees next in respect of different Khotiyan numbers, the names of the riots are given. Second, Ashok Tibrewal, all are this family. Then kindly skips 5-6 names. Then your lordship will find Durga Dutt Tibrewal in Bengali. I'm really sorry, we should have given a translated copy. Then Payal Saraugi, then Pradeep Kumar Saraugi, then Bhagavati Devi Saraugi, Ranjana Saraugi, Rajkumar Saraugi, Sham Saraugi, Sushila Saraugi. So your lordship will find that this land is still, as on 11th May 2024, in the recorded names of these persons. So we never had any occasion to doubt the existence of the land or with regard to any proceedings initiated in respect thereof, if we were not known. And our boundary wall is there. Pages 89 onwards, we have given photographs to show it is still vacant and is, it's walled. Page 89 onwards,
Okay.
going up to page 92. But it goes up to page 92. Then 93 and 94 are Google Earth images, which would also show that this is still lying vacant. But I'm led by Mr. Mitra, if your lordship kindly grants me.
Yes.
Was placing. But before I come to the pleadings, I want to give the lordship a brief overview. There is, by a notice issued in the year 2006, a notice under sections 4, read with 17, that urgent acquisition. It's in the month of January 2006. Several of my properties are attacked together, where different co-owners are there, within the family, different combinations. Now, my lord, interestingly, there is Dag number, as Mr. Gupta was showing, Dag number 4449. This is one Dag in respect of which the 5 several writ petitions are pending. Because we have to file 5 writ petitions because it's in a different combination of ownership. And different notices that come to for the different portions. Now, the Dag number 4449 of the 5 writ petitions, one has very kindly restored by my lord a day before yesterday. One pending, other 3 dismissed. Now, there's a story behind 4449. 4449, unlike the other Dags, it's a big tract where 5 of us, 5 groups, different combinations. It is entirely unused. 2006 urgency it's historical. Fully unused, fully in my possession, as Mr. Gupta has shown, and record of rights still shows the names of my family members. So this is the position with regard to 4449. Some of the other Dags for which they gave notice, there has been development. There are different places. Record of rights has been mutated, has been mutated or corrected, or whatever may it be. There is a mutation because subsequent development. So that is we were always under the impression that this Dag was never really implemented. Now, another very important fact is, I am the petitioner number 2. My name is Sushila Tarao. You will find the main writ petition and other writ petitions also wherever he is there. Rajkumar Saraugi is my husband, the first petition. He was the one who was handling. Petition affirmed by him, whatever, and other writ petitions were also affirmed by him, and he was handling this matter. 2006, when the notifications came, which came to our knowledge, we filed a writ petition 2006. And affidavit directions were, now it's all comes out now. 2006, affidavit directions given, writ petition pending for years. I was not aware of that is petition number 2, and the others are relatives. There are some relation, nephew or something. So, 2000 and in the year 2015, my husband, who was at that time in his early 50s, fell suddenly ill. 2015, very seriously ill. I have annexed documents, medical, in and out of hospital. 2008, at the age of 58, he passed away.
18.
It was 18. He passed away. Well, we were under the impression that this is the Dag where the property is not, after the petition was, we had some idea of a proceeding being filed, but this ownership was always with us. Because we would go sometime, not me, some manager or somebody will go and take a look. It is intact. Nothing has happened. So in the year 2023 or 24, when we ultimately decided that let's sell off this land. When we decided to sell off this dark number 4449, we went to brokers, and then it was found out that the government had last year come up with basically to sell out this land, a private public partnership, which is the usual way. Let a private developer come, develop this land, give me a part of it, like every owner does now. One doesn't go for an outright sale, one goes for development. So this is in that model. The government had apparently published an advertisement last year, but nobody really came forward. This we know from the brokers. And then we find out that the writ petition apparently was dismissed for default in 2015, along with some other writ petitions. Some remain pending. Now, so once we come to know, make the full inquiry, Mr. Abhijit Sarkar, our advocate, is no longer interested. He has had some issues in his own personal life. So the things are, we have taken a change and we have filed the writ petition. In the writ petition for the first time, sorry, not the file writ petition, my restoration application. In the restoration application, they are now claiming that there's a compensation was assessed. However, they have not given any proof, any notice required under Section 9(3) of the Land Acquisition Act. Personal notice is required. 9(3) before finalization of compensation. That is the only place where Section 4, I think, and Section 9(3), where personal notice is required, apart from the public notice. So those Section 9(3) notice has not been disclosed, but they are saying there's an award. That's on merits. So, my lord, we want to really restore the writ petition. If the years, please do not ask me, there are many. But the facts are this. And everything is supported by documents. Whatever I am saying is supported by documents. And there are real reasons. There are judgments which, as your lordship, there are judgments where there has been restoration many years later on different grounds. So I was humbly beseeching my lord, whether the so it's a 96. So, ma'am, so which was allowed day before yesterday, of course, was dismissed, happened to be dismissed 1 year back. But everything was in the dark till such time as we find out from this broker that there was this public-private partnership announced, public notice. Notice PP notice. This whole thing came to our knowledge when our broker found out from the 117 commercial company. This was dug out from the newspapers. Really, this is what was really found out is the page 118. It goes expression of interest 118 published.
Where is the dark number?
Well, okay. This is given at 120. And the scope of the work is also paragraph 4 towards bus terminus come commercial complex. So this is really a development where the bus terminus will come to the owner and the rest of it will be privatized.
Okay. Yes.
Now, Lordship, this is my source of knowledge. After I find out from, after I engage brokers for the genesis of the problem is page 67. The whole genesis, which I will not go into facts now, but one can't shy away from the fact that private person's property was thought to be acquired without right of objection under section 5 at page 67. Just above the land schedule, Lordship will see in exercise of powers conferred by section 17(4). That's very urgent. The governor is pleased to direct that the provisions of 5A of the Act shall not apply to the land. And
all are merits, my lord. But one thing I must submit before your lordship, that there is a knowledge, my lord, there is a third party. There is 117, my lord, if your lordship, my learned friend, my lord. 17, 118, my lord. Shows, my lord, but that party is not a party of this proceeding. That is the West Bengal Housing Infrastructure Development, my lord. As because, my lord, we have acquired the land and he is the recurring body. After that, it was transferred to the position was
actually, after it is restored, the question of addition of party will arise. Because if they have transferred it afterwards.
On the previous occasion, my lord, I told before your lordship that
In
certainly,
that
yeah.
case also it is restored.
Of
Now
course, it will
I
have
have
to be
given it to appear under the
after
heading direct
restored, my
direction.
lord, I have taken the point, my lord, some point that day to day, my lord, clarification was not there. And my lord, if you না আমি শেষে বলবো ওই পয়েন্টটা বলা যাবে না তুমি বলো
seriously.
আবার এটা তোমাকে নিয়ে পারি না কি হলো
Yes.
My lord, I was
Well, I agree, but HITCO will possibly, since if they have afterwards they have handed over to HITCO, HITCO will become a necessary party in the writ petition. Now, the genesis, as I said, is page 2000 is page 67. Now, Lordship kindly sees page 83.
My lord, I may not want to go into the merit now, but that's because I am not putting any opposition in the merit.
Opposition.
No.
Opposition there আছে.
In opposition to section 5.
Yes, section 5.
Restoration application. My lord, I am not giving the abitability in opposition in the original writ petition, my lord. I am only stating that the facts which is, my lord, according to section 5, I am challenging that. Whether this is a day-to-day explanation or anything else, my lord. I am not challenging another things, my lord. Previously, my lord, everything is there, my lord. If that is in accordance with the section 5 application, my lord, there is a, my lord, explanation is there, my lord. I have nothing to say, my lord. Your lordship can. I only took that point, nothing else, my lord. So I request my learned friend, my lord. He can, only my lord, he can section 5 application. He now wants
Yes,
to do. If
I
my learned friend, my lord, convince your lordship, I can't say anything, my lord, as because section 5, I, according to, as a state advocate, my lord, I never oppose anybody. But my lord, according to them, my lord, if there is something is not, my lord, clarified in only for that reason, my lord, if my learned, I request my learned friend to, my lord, submit only for the cause of the in terms of the section 5 application, which is filed in this application. For merit, my lord, that is, I am not, now I may not want to submit anything, my lord, now.
I would request him not to make this exception. He generally never opposes
Yes,
restoration.
my lord, I never
Why should
oppose.
this be an exception?
Yes, sir, my lord, I never oppose. It is my, in every court, my lord,
I
never
know.
oppose, my lord.
Anyway,
I am very sorry, my lord.
I think you have covered the.
well, I have covered. I want to show page 83 is the order where directions were given for filing of affidavit, 2006. 2006 affidavit directions are given. No opposition filed.
Lord, if section 5 is, my lord, is okay, my lord, I have nothing to say, my lord.
And my lord,
Want to
the dismissal is page 82. None appear. Neither side appear. Neither side appear. Page 82, the matter got dismissed. So it is not that they appear. And number 3 is I cannot explain anything because page 95, before 95, Lord, you see the repetition also. Page 95, my husband passed away. And Lordship will see the repetition, which is the next year. Can you see page 48? It was affirmed by my husband. So he was the elder, and other one was nephew, and one nephew and his wife and his widow. So page 40, Rajkumar Saragi, who was handling the case, he passed away on 14 November 2018, page 95. Page 9. And then, my lord, straight away I will come to what I have, not Mr. Gupta has shown, that I had no reason to really anticipate anything otherwise because of record of rights, photograph, there was no change. I was under the bona fide impression that this was pending, and then after that, when I found out, I gave a day-to-day explanation since Lordship kindly see. Lordship kindly sees when we found out about this. Yes, Lordship, paragraph 15.
50, 15.
15, page 10. This is really how I come to know about the writ petition being dismissed. The petitioner thereafter decided, after check record of rights, everything, thereafter decided not to retain DAG number 4449 and wanted to sell it on as-is basis that is subject to all pending litigations, including the present sometime around June 23. For this purpose, the petitioners engaged one Ranjit Gupta, a real estate agent. Site visit was carried out by the real estate agent as well as the petitioners. In course of time, due diligence was carried out by the petitioner. Searched and downloaded on this is apart from the ground reality as stated above. The said broker, while carrying out the due diligence exercise, came across a proposal of the state government to set up a commercial bus terminal public-private partnership basis, for which the expression of interest was published in December 20. It was also ascertained that the expression of interest had failed since there was nil response there to this proposal. There was nothing but an attempt to commercially utilize DAG number 4449. The city would not be setting up the bus terminal or incurring any cost in this regard. The cost of construction of the bus terminal would be nothing but equivalent of the consideration that would be given by the private party for acquiring the land where the commercial complex would be set up. The commercial complex would be sold and leased out by the private party, in which no public interest would be served, even though, around December 23, the petitioner accordingly advised by the real estate as a file application pending writ petition because I was thinking it's pending writ petition. Rajkumar Saragi died on this date, and the other writ petitioners pending familiarize themselves, and in such regard contacted Obhijit Sarkar, advocate, on or about 12 January. In the said meeting held on 12 January, Mr. Obhijit, it was prima facie decided that an application will be filed in the present writ petition seeking interim relief. Accordingly, Shantanu Chatterjee, advocate, was instructed to draft an interim application in the present writ petition. Draft was dictated by concerns, all those details are given. Covering letter.
Okay.
And then suddenly it is found that, that the matter is dismissed. Paragraph 17N, and then
That means you started your searching after the notification.
Yes. After this expression of interest was published, and when my broker was engaged to fill the land, that's all this was found out. So
Yes.
that is really all. Well, I have a judgment, but these are factual matters. I have a judgment where there is similar number of days delay. Mr. Gupta and I were all on the same side, and it was restored. Just to keep on record, it was restored a writ petition after 2696 days delay. On the facts of that case. I mean, just check it. Division bench judgment. এই তো গিরিগুপ্ত আছে মঞ্জুরা ছিল তো গিরিগুপ্ত দশমের জজ কয়েছে গিরিগুপ্তর জাজমেন্ট
No, no. This is Justice Chelur.
Lordship kindly sees that the first paragraph.
Yes.
Delay of 82 and delay of 2696 days review of Arkan. The first thing, Lordship, is the first paragraph. 2696 days delay was controlled. And then one goes into the minute. So the very first paragraph. So this is all I'm saying is that this is এখানেও আছে এখানে কন্ট্রোল করলো গিরিগুপ্তটা করলো গিরিগুপ্ত যেটা আগে রেস্টোর করেছিল
If you need writing, please.
I really would not. These are factual matters. I will.
My lord, I may not want to ask my lord of other. Your lordship will come on 17, paragraph 17, page 11 of the
Restoration or condonation?
restoration. Similar point to all the point. My lord, that is
Yes, para 17.
20, my lord, your lordship. In or about second week of December, the petitioner were accordingly advised by the real estate agent as also the other members of the association. Rajkumar Saragi has expired on 14th November 2000. The other petitioner had no clue about the ongoing petition and to familiarize themselves with the present writ petition or with the other writ petition mentioned above, and such regard contacted Mr. Ogiji Sarkar advocate on or about 12th January. In the meeting held on 12th January, and Mr. Ogiji Sarkar advocate, it was prima facie decided that an application will be filed in the present writ petition seeking interim reliefs. Accordingly, Mr. Sayantan Chatterjee advocate was instructed to tap the petition in the present writ petition. The tap was that treated by the Sayantan Chatterjee and sent to Ogiji Sarkar advocate for finalization sometime around 1st February 2020. In the regard, a copy of the memo dated Ato, Mr. Sayantan Chatterjee advocate along with a copy of Mr. Ogiji Sarkar Ato are annexed thereto and marked with the letter. After that, my lord, according to Ogiji Sarkar advocate, he was always under the bona fide impression and believed that the present writ petition and other petitioner were pending, reason to suspect that the writ petitioner were dismissed for report. He justified his assessment in the premise that the respondent who had taken a direction to file an affidavit in opposition had not filed, and such affidavit accordingly the writ petition was not yet ready for it. Be that it may be, the petitioner, having lost all their faith, trust and confidence of Mr. Ogiji Sarkar, engaged Deepraj Basu advocate in or about first week of March 2024 to take immediate steps in the matter. Deepraj Basu advocate.
I leave for just fine.
Junior counsel who would appear and advise the writ petitioner, it may be stated that Mr. Sayantan Chatterjee advocate who is already engaged in the matter was retained by Mr. Deepraj Basu. As there were several petitions that complicated facts involved, Deepraj Basu advocate along with Sayantan Chatterjee advocate, writ petitioner had differentiation between the period of 9th March and 26th March 2024 in the chamber of Vikraj Vasu advocate and understand the matters and Ato, the authorized representation of on the Kiran Kumar Satyanja and 27th March 2022 advocate and representatives of the writ petition. Mr. Santal is one of the writ petitioner of Ato, Basu on receipt of the said produced each other. After being acquainted with the facts, the conference was made. Accordingly, conference were again I am consultancy and Ato and representative advocate drafted restoration application.
What I'm asking. But I am requesting my learned senior friend not to vehemently oppose the restoration. And if on merits he opposes it, that's okay.
My lord, I may not want to, my learned junior will, as because he is my friend's son, my lord. He requested me, no, my lord. My learned friend will.
কি অপোজিট করতে চাইছেন? Who you are appearing, Mr. Bandyopadhyay, in two?
Yes, my lord. With my
Item
junior.
number 2 and 3, but similar matter, I have identical.
Okay, but
It was Mr.
so you say that there is no day-to-day explanation of the deal. That is
That is the main, my lord.
And then aspect, but then also my lord, in the second petition, this petition, my lord, after recalling, they are my lord playing for the substitution.
But I agree, my learned senior friend had shown the fallacy in the draft. I have considered
This is not
that we'll have to pray separately. But I
record your
yes, restored, it cannot be done. It's a we are not pressing.
Since in Supreme Court by the first and order by the day-to-day explanation must be my lord. Otherwise, this court cannot be taken.
Ashok. That's all.
এই সব
My lord, I am sorry that I.
Okay.
And my learned friend is there, my lord, so it is not difficult job for me, my lord. Opposite.
No, on merits, I cannot have any say. But
Can first in 2 2024. This is an application for under Section 5 of the Limitation Act for condonation of delay in filing the restoration application. Mr. Abhrojit Mitro, learned senior advocate, appearing for the applicant, submits that the writ petition has been filed challenging an acquisition proceedings of the year 2006. Thereafter, directions were issued for the state respondents to file affidavit in opposition. In the meantime, on 20th July 2015, the writ petition got dismissed for default, since none of the parties appeared when the matter was called on. The petitioners who are applicants who are legal heirs of original petition number 1 and 2 were unaware of the order of dismissal.
Number 2 only.
1 and 2, no?
So one died. So that also I'll have to have it.
Two is alive.
Two is alive.
Two is alive. Legally also
Number one.
petition number 1. Further, he submits that the original petition number 1, Rajkumar Sarogi, was the person who used to look after the legal proceedings of the family. Stop. Due to his chronic ailment since 2015, and his expiry in the year on 14th July. What is the date of death? On 14 November 2018. Requisite steps could not be taken in the writ petition for restoration since the applicants were unaware of the order of dismissal. In the meantime, the parties tried to sell out the property within DAG number 4449, and they were informed by the broker of the notification floated by West Bengal Housing Infrastructure Development Corporation Limited, dated 9th August 2023, for construction of international, intrastate, interstate, intercity state of the art bus terminus cum commercial / business complex. On searching of records thereafter, the petitioners, applicants, came to learn of the order of dismissal. And thereafter, the application has been filed for restoration along with an application for condonation of delay. There was no laches on the part of the applicant in taking steps for restoration of the writ petition. He seeks for restoration of the writ petition. Acha. To buttress his contention, he relies on a decision of this court passed in 1811, APOT. He seeks for restoration of the writ petition. Reply you are filing today? You are filing the reply today? ওই উপরে দিয়ে দেবেন affidavit and reply file on behalf of the petitioner. Okay. কি বললাম? হ্যাঁ, to buttress he seeks for restoration upon condonation of delay. On the contrary, on the contrary, Mr. Chondi Charan De, learned additional government pleader, submits that there is no day-to-day explanation of delay in the application for condonation of delay. And therefore, the grounds spelled out in the application for condonation of delay does not merit consideration. He submits that the full stop, he submits that the application should be dismissed in limine. On going through the application, it is found that the petitioner number 1, it is contended categorically that the original petitioner number 1, Rajkumar Sarogi, used to look after the proceedings. He said Rajkumar Sarogi expired on 14th November 2018 after suffering chronic medical ailment. It is also contended that the petitioners did not have any clue about the ongoing litigation. Since they were not familiarized, they were not in familiarity with the writ petitions. It is also contended that when a broker was appointed to for selling of the property, through him, the petitioners came across a proposal of the state government to set up a commercial complex cum bus terminal at Dag number 4449 on public-private partnership within bracket PPP basis, for which an expression of interest had been published on 9 August 2023 by the West Bengal Housing Infrastructure Development Corporation Limited, HIDCO. It is only after December 2023 that the petitioner applicants started to search and came to learn of the dismissal. Order of dismissal passed on 20th July 2015. 20th July 2015. Considering the submissions advanced on behalf of the petitioner and the averments, this court finds that a sufficient cause has been shown to condone the delay of 9 years, 3 months. Accordingly, such delay stands condoned. Application being accordingly, application being can 2 of 2024 stands allowed. Can 1 of 2024, this is an application for restoration of the writ petition. In view of the discussions made in the foregoing paragraph, the order dated 20th July 2015 is hereby recalled. The writ petition being WP number 23429 within bracket W of 2006 is restored to its original file and number. Application being can 1 of 2024 stands disposed of. Writ petition WP number heading closing 23429 W of 2006. Mr. Chondi Charan De, learned additional government leader, seeks extension of time to file affidavit in opposition.
On that day, my lord, previously, my lord, another matter was fixed on 12th. On that day, my lord, your lordship will.
12th.
Yes,
12th of
12th May.
February, the other writ petition has been
Okay.
After yesterday, my another.
Fixed. Let such affidavit in opposition be
No, my
filed.
lord. On that day, my lord, your lordship passed that order.
My lord,
As
in the
because, my
other,
lord,
in
they-
the other petition, my lord, your lordship
What was
will-
the direction? For directions, it will
No,
appear.
It was
only
just
things-
kept, my lord. The main writ petition has been directed to
Restored,
appear
as
on
because-
12th of February.
List, list WP number 23429W of 2006 on 12th February.
Yes,
On 12th February. Two also same, Mr. Bandobad?
2 and 3 are same, my lord. Only in respect of, my lord, the writ petition numbers would be different, my lord. And the only first paragraph, my lord, when your lordship is recorded, my lord, the death of the petitioner number 1, there, my lord, everybody is alive. They are all legal heirs. My lord,
Which one?
My lord, 2 and 3 both, my lord. Only the first paragraph would be altered to that extent, my lord. They are legal heirs. Nobody has died in that. The petitioners are alive. ভিতরে বলা আছে, ওটা শুধু ওই paragraph টা।
না না বুঝিনি কি বলছো?
You know, in this particular petition, you know, the petition number 1,
You have not pleaded in 2 and 3 the Rajkumar Sarogi.
that we have pleaded, my lord.
Yes. Then
But
who has died?
Rajkumar Sarogi is not the petitioner in those two, my lord.
Okay, okay.
That's the only change.
Who is the petitioner then?
My lord, the other legal heirs, my lord, name.
Pradeep Kumar Sarab.
আচ্ছা বুঝেছি।
That's the only change, nothing.
Pen.
এখানে petitioner number 1 মারা গিয়েছিল। ওতে petitioner number বেঁচে আছে। Legal heirs, sir. আমি বলে দেবো। টাইম নষ্ট করছি না।
ওতে petitioner আলাদা আছে। এটা দিয়ে Rajkumar Sarogi is one of the petitioners. In other two, Rajkumar Sarogi is not the petitioner. But he used to look after
Yes,
the. This is your.
absolutely. Yeah, absolutely.
Okay. বুঝতে পেরেছেন?
There's another, you know, as Mr. Mitra had pointed out, you know, there were 5 writ petitions, but 4, your lordship is pleased. না সেটা তো অন্য দাগের, এই দাগ নিয়ে আমরা করছি অন্যগুলো। But there were 5 writ petitions. Your lordship has passed directions on 4 of them now. But 1 is still pending. It has not been dismissed. Will it be your lordship's pleasure, my lord, to direct that particular writ petition also come on the same day, my lord? Then similar orders can be passed, my lord.
No.
Or I shall mention that, my lord, before your lordship. My lord. On the returnable date, I shall mention.
Are you? Sorry about the appellate side.
Item number 4.
With my application for restoration, but I was held by Mr. Muslim. I've already served the state and the affidavit of service.
Affidavit of service.
Delay of 107 days in restoration.
Affidavit of service. Application গুলো আছে? Can দুটো কোথায়? হুম 7 days.
Explanation for the reasons for dismissal of the matter is mentioned from paragraph 3 onwards. Your Lordship.
Yes.
But there is a delay of 407 days. Though that I application For hearing.
You have filed your opposition.
No, my learned
There was a
not
direction.
objecting to the restoration. Regarding restoration, I have no objection.
You have filed your opposition to the original writ petition.
No, my lord. It has been served just in this filing of the restoration application. Served to us. Following your lordship last direction, the copy of the restoration application along with the writ petition and the condemnation of delay, 3 of the applications have been served upon the state.
There
was no chance to file.
It's an application for condonation of delay. Just when so learned advocate appearing for the petitioner submits that the clerk of the learned advocate on record no. When was it dismissed for default?
Lordship on the 30th August 2023. It's annexed, your lordship.
The matter was learned advocate clerk submit that the matter was running in the warning list from 25th July 2023. So the clerk of the learned advocate on record failed to inform the petitioner or his learned advocate and as such on the date the matter was called on, it was unattended. Stop. The petitioner contacted his learned advocate in the first week of July 2024 and came to learn of the order of dismissal. For such reason, there is delay of 407 days. He seeks for condonation of delay. And the advocate for the state respondents leaves the matter to the discretion of the court. On perusal of the averments made in the application, it is found that the cause shown is sufficient to condone delay. Accordingly, delay of 407 days in filing the restoration application stands condoned. The application being can 2 of 2024 stands disposed of. Can 1 of 2024 this is an application for restoration. Considering the submissions made on behalf of the petitioner and the averments made in the application, the order dated 30th August 2023, order of dismissal is recalled. The writ petition being number WPA 19663 of 2014 is restored to its original filer number. Writ petitioner heading present. You have not filed your affidavit. No? Mr. So-and-so, learned advocate for the state respondent seeks to file affidavit, seeks extension of time to file affidavit in opposition. If such affidavit in opposition be filed within a period of 3 weeks, or reply thereto if any be filed within a week thereafter, this matter after 4 weeks. Right, the copy there in affidavit of service filed. It
would be your lordship's kind pleasure to keep this matter in the monthly list of March. I have some personal difficulty The last week of February, you know.
police করে আসো
Item number 5.
এই শুরু হবে
My lord, the other side, they have finished the argument. ঠিক আছে ভাই?
হুম
So, respondents, both the respondents have finished the argument. I am just replying the argument. Now, my lord, as I am told, on and from Monday, my determination has been changed. I'll get only 45 minutes. I'll try to finish within that time. Of course, this is a parter matter. Anyway. No, but I cannot deny the supremacy of the state. The concept of eminent domain, everybody knows, my lord knows better than me, that is there. But take the advantage of that. If I find really there is an arbitrary, malafide, illegal, reckless action of the authority of the state, certainly I can knock the door of the temple of justice. I can say, my lord, kindly see, this is the situation. After all, it is my property. They should not snatch the property in this way. Their case is this, it is acquired. Award has been declared, has been withdrawn, which is contrary to the record, not that everyone has taken the award. And they want, maybe it was taken for the other purpose, but now for service road, they require it. These are the two facts. Both of them, they argued. This is the crush of this argument. I just, excuse my importance to remind your lordships, I just submitted your lordships. I don't mind. If anybody at my cost right now go to that place, what is the position, they'll find. Why I'm come to that. So, my lord, at the cost of reputations, eminent domain is there. And that should be there because in a democratic country like India, my lord, property of a citizen can be snatched in this way. So some power must be given to the state so that they can take property for the construction of a road, bridge. Naturally, it is needed, and nobody should be compelled to hand over land to the state. Now, my lord,
yes
I just pointed out to your lordships, my lord, that entire fact I have narrated. My lord very rightly put me on questions. Mr. Banerjee, what about the tax or the rent? They have accepted in your name? Yes. I produced a document, my lord, in the petitions. Now I find why my lord put this question to me for obvious reasons. Because the question of adverse possession will automatically come. That point I'll just finish today. I'll argue this, my lord. Now, my lord, very interesting. Excuse my impertinence to remind your lordships, my lord. In one occasions, I just handed over to your lordships the judgment, a volume of judgment of Supreme Court. That is K.M. Joseph. Because right from the beginning, their stand is this. This is an old concept. Once it is vested cannot be divested. That has been totally diluted by the judgment of the Supreme Court. It cannot be. Taking the advantage of this eminent domain, you cannot keep it pending for years together. Because after it, you are taking the property of the citizens. Now, kindly take trouble. Very interesting, my lord. Though it is a part of the record, it is mentioned in the petition. Lordship, it is out of it. The petition.
কোথায় অ্যানেক্স করা হয়েছে
For the convenience,
এটাও আবার yes
kindly see this particular map is not my map. I'll come to the second one, my lord. First one, my lord. The red marks, they are the acquired property. The red marks. Have you also got it, my lord? and the green, they have released. And kindly see the position of the land, green mark, inside the red marks. Have you got it, my lord? They have released all those things.
This
And
has
kindly-
been relied by whom?
We have relied in the petition, we have annexed. But for the convenience, I'm just giving it. It is not that off the record I'm saying something.
Okay.
And this is the road. Here is the road, my lord. And just above this red mark.
Hmm.
And between the road and the red mark, which is acquired, kindly see, all are unacquired property.
Your property is which one?
6, 8, 6 to 8, 5. On the left side at top, just on the side of the green mark, 6 to 8, 5. Have you got it, my lord? I'm just indicating, kindly take out this one. This one. On the left side, top, and just as to the green, which has been already been released. And in between the road and side road, some lands are other plots are there, which has not been acquired, which is very relevant. More than malafide. Please, I'm sorry. Petition has taken 185.
সরকার দিয়েছে কেন?
185, 185, তাই তো 185. উত্তেজিত হসনি? Anyway, my lord, so this is the position, topography, because that is one of the main ground that land is really required for the side road. Kindly see, my lord, the picture which I have handed to my lords is, my lord. Have you got it, my lord? Pictures. In the side road is already there. Trucks, there is already park. Have you got it, my lord? After that, the main road, one truck is visible. And in between my land and this, these are all government land. That subs are also there. Green subs also there, my lord. It's absolutely arbitrary malafide. So had it been a case, my lord, that well, my accord land just adjacent to the main road, I could have understood. In between main road and the non-accord government owned land, there's a side road where the truck is parked. I expected that when I submitted your lordships, send anybody here, they'll immediately accept it. Yes, we don't care. Go and they will not accept them for obvious reasons. Because the picture is totally otherwise. The fact is otherwise. And a desperate attempt has been made to justify their misconduct. If I permit to use this word, my lord, that and malafide, they say, yes, I admit the land which was acquired, Mr. Manager's land which was acquired for some other purpose is finished. Now I can use it for other purpose. Very well. For what purpose? For side road. Kindly see, this is something which is contrary to their own statement and the actual position. And in this way, I have been deprived. Similar circumstances, the green mark, copy there, green mark plots, they say once is vested, can be divested. What prompted you to release all those lands? Some or other connected with MLA, MP and others. I'm really sorry to say. So green portion, and see the position of the green land inside this backward plan. How's it? So keeping this land as it is, because since it is released, how they'll construct new thing? And these are all the state land which can be used if at all. It's absolutely malafiding, my lord.
Yes.
I cannot blame my friends. I like them. They are all my junior brothers. They are very efficient, honest. They always try the level best. But whatever instruction they have got, they have just handed over to your lordships. No other alternative. Because I know this happened. Because I had a privilege to appear, act as a government at the advocate general. All those things has been done by some persons. Who is actually pulling those things sitting behind the scene for any other purpose? I do not know. So rare contention. Yes, purpose for which it was taken, maybe it is evaporated, but still we can retain it for a particular purpose. And I'm really thanks a lot to them that disclose what is that purpose. Purpose is like this, which no cannot be accepted. So there, one branch of argument to keep the land in their own hand cannot stand in the eye of law. Factually, it is not correct. I took the risk. I don't mind, my lord. Immediately, kindly send anybody right now. My statement is not Dhubosotto. So if it is found, what will be their position? That's why they will not agree. So I need not disturb your lordship any further regarding that requirements. If the requirement goes, everything will go. Because land which was acquired for the purpose, that is gone, finished. Now question is this, whether at all it can be divested. Came to the judgment is very clear that you can't do. You cannot keep the land for years together. Oh, tomorrow or day after 100 years or 50 years, I may use this land. No, that you can't do. That you can't do. Now, even the question of award might not very unfortunate. The acquisition also not regular, irregular. And in most of the cases, it's being done. My lord is surprised to note that at the one point of time, there's 18 contempt against one officers, IS officers. He is now the principal secretary of health. 18. Another against another one, 16 contempt. Why? They are the officers. The government will be there, but the party will come and party will come and go. What was the position? Without any acquisition proceeding, property was taken. Court says, why you are keeping in your hand? Or you have not properly acquired property. Release it. That was not done. Justice Indiraban Judge lost it, Mr. Manager, with a smile. How many complaints are there, Mr. Manager? Now, this is the situations. So I cannot blame also them. They are all under the control of some people who has got no accountability. They can say so many things. They can do so many things. But the lawyers, the honorable judges, the lawyers, the officers, they can't do anything and everything. They're always available. But very unfortunate, my lord. Law doesn't mean to be mere theoretical abstraction. It is an instrument to the justice. The way they are handling their law, they should be permitted, my lord. It's very shocking. I don't mind if it is done properly, because I have already considered eminent domain is there. They were right in a proper case, proper manner, a proper way. Is it the proper way, proper manner, proper purpose? So, my lord, neither for the widening of for the service road, nor for the service road, main road is viable, nor acquisition is done in a proper way. So what remains? Nothing. Nothing. So this is the way I am being deprived. My lord, the persons who have been obliged have got the blessings from the authority. I've given the green mark. What were the reasons? Why they have taken the land initially? Why you decided to take the land? If you think that it is not needed, kindly see the topography. Green at the cost of limitations. Just in the middle, inside the lake. So what purpose to be served? And I must frankly confess, no, that was stated in the petition itself. My motherland in between the service road and my land. That is not acquired. So, what purpose to be served? For even for construction of service road, how they can take the land, my land, without acquiring my mother's land? It's a cock and bull story.
Yes.
My lord, very interesting. I couldn't understand that well. I must give a thanks to them. In my case also, proceeding was started but to release the land. Kindly come to page 94 of the paper book. In the paper book, my lord.
My paper. Yes.
Have you also got it, my lord? 94. Government of West Bengal, Office of Sardar, is a letter. Paper number dated 27 June 1994 on the right side at the top to the executive engineer periodically. In enclosing here is a copy of application of CC 20,000 and so others of such and such along with a copy of the site plan. The undersigned would like to request him to let the undersigned know his view, letting release the plot such and such as mentioned in the application. If the department desires to release the land, a formal pair for relinquishment and relinquishment along with 4 copies of the plan showing portion of the land to be relinquished should be sent. So not that no attempt was made in case of other also. Now,
This is not the only plot.
this is not the only plot.
This is one plot.
Some other plots also there.
Oh, other applications are also there.
Yes. So, I'm sorry. So admittedly, similarly placed persons, since they have obliged the land acquisition officers, sent a letter to the executive engineer. For obviously, this is why they have a discrimination, because it's an honest officer. Approach is correct. So kindly consider it and pass the order. Nothing was done, which compelled the parties to approach that Honorable High Court. Justice Nirendra Krishna Mitti, as he lost it then was, passed the direction. Page 98. I'll count page 98. Please got it, Mahila. 95. The read application is disposed of by directing the authority concerned to consider and dispose the annexure 3 to the read application. In accordance with the law, after hearing the party petitioners, taking into consideration the document and appears to be filed at the time of the hearing and by passing a reasonable order, positively within 12 weeks, and which the petitioner continue communicate with them. Till today, nothing has been done. An order of status quo was passed. At bottom, kindly see. How they can take the land without vacating that? Nothing has been done till today. They kept mum. Here also, says my friend, very beloved friend, they are not instructed. They have not already keep mum. What am I to do? So this is the picture which I place before Lordship to understand the position and their approach. What is actually cause of actions? For taking actions, well, some persons they move away, public interest litigations. Now, their Justice Chief Justice Jyotirmoy Bhattacharya passed an order. Very well. Illegal authorized, kick them out. Now, matter went up to the Supreme Court. Kindly see the order of the Supreme Court. Very interesting. It's at page 104. Very interesting.
10.
4. Start from the 104. The Chief Justice and Justice Sanjay Kishore Krishna. Have you also got to upon hearing the publisher to file specially for article suspicious. Then next page, which is very interesting. Next page. Have you also got it, my lord? Delay conduct. As the learned counsel appearing on behalf of the public in the litigation, petitioner has made a statement that in the meantime, the petitioners have been evicted. The petitioners have been evicted pursuant to the notice issued in charge of the High Court order. We are of the view that the petitioners should be left to be ready to approach the High Court for appropriate. That's a different thing. That disposes, my lord. For obvious reasons, court say, if you say that well, you have been disposed illegally, go and challenge. But they are disposes. So cause of action gone. Cause of action gone. I could have understood that well, they serve a notice which has got no nexus with this particular aspect. So long they didn't take any actions. They allowed, the government allowed, they accept the revenue. My name is recorded in the record of right. So naturally, for more than 30 years, we have been enjoying this property adversely. Now I can use here, not only like 53A, my lord, the imported Indian apple, my lord, can be used as a sword, shield, not but a sword. But now Supreme Court has clarified, it can be used as a sword as well as shield. So, question of adverse possession, very material. Here also, my lord, limitation is a very major aspect. Law of limitations. That well, except the granting of probate and other things, my lord. And now Supreme Court is thinking whether restriction has to be imposed, even in the case of probate. In the probate, there is no limitations. But revocation of the probate, well, there is a limitations. So that's why, my lord, they allowed us. I've been doing my business over there. My livelihood has state article, violation of article 21. When we started our practice, article 21 was not much important. Not other. Subsequently found is a gold mine. Of course, for the lawyers, I should say. Because life includes livelihood. And the other day I had a privilege. Normally I do not appear in the criminal case. But I was compelled to appear in one case few days back. Just New Justice Supra Ghosh regarding granting of bail of Jyotipriya Mollik. Milan Mukherjee also there, my junior. I took 1 minute time. I submitted. Kindly consider Article 21. Justice Ghosh very rightly told me, Viswaji, that will prevail any other things. No, that can be done. I said, very well, as well also think. Just after 4 days, Supreme Court, my lord, considering the Article 21 granted bail for persons regarding this case. Just after 4 days. Probably marginally by. So Article 21, very major aspect. We are in a democratic country. My livelihood at stake. I am not allowed to do chini-mini with my property and my livelihood. How is it? And no question of compensation. Whether at all you can do it or not. Whether at all. If you can do it and do it legally. But you cannot do something which is you cannot directly, you will do indirectly. Article 21, a very major factor. Today there is no cause of action.
Yes.
Now, my lord, I cited earlier, I cannot remember. One very interesting judgment. I like this judgment like anything. The judgment of Justice Madam very first day we need to court and sat with senior Chandrachud, the Chief Justice. I had a privilege to appear on the very bad lordships. R.S. Pathak himself and T.P. Madan, which is reported in 87 Supreme Court, 537.
Yes, you have
Now, well, at the cost of repetitions, I'll place paragraph 19. Copy I have handed to Lordship, my lord. Everything got it, my lord. Paragraph 19, last lines, last paragraph, few lines. In Hospital Laws of England.
No, this is marked. You have placed it.
Huh?
I have marked it.
For my satisfaction,
Oh.
I am deeply grateful, my lord. In Hospital Laws of England, Fourth edition, volume 1, paragraph 1, it is stated that the purpose of an order of mandamus is to remedy defects of justice, and accordingly, it will issue to the end that seems to be done in all cases where there is specific legal right and no specific legal remedy for enforcing that right, and it may use in cases where although there is a legal right, tentative legal remedy, yet that mode of redress is less convenient, beneficial factor. There is thus no doubt that the High Court in India, High Court in India, I just stop here for a moment, my lord. In High Court, my lord, Article 226. Supreme Court, Article 30. Of course, my lord has not got any power from the Constitution like Article 142, which the Supreme Court judges are enjoying. They can do whatever they 151 is here, but power of Supreme Court under Article 142 is much more wider than any other things. I remember one incident, Justice Joseph asked that this man, contempt was issued against him, or money for charge. Rule issues appeared. I also appeared. He said, my lord, there is no post. Look, I can tell you one thing. I am giving you fortnight time. And this bench will hear, because Supreme Court sometimes benches are changes. Bring all the appointment letters. You know Article 142? I'll treat you what is what. He was a very quiet. And ultimately that was done. So that's why power of the Supreme Court, my lord, is less than to some extent, because only Indian citizens can challenge the order due to the Supreme Court, because unless the fundamental right is violated, Article 2. But even a foreigner can come to the lordship and move Article 226 if they violation Article 14. So Article 14 within the fundamental chapter, but basically is not a strictly fundamental right. If it is a fundamental right, how the foreigner can enjoy, they can't do that. And 19 is start with a citizen. Marked in my lord, the Constitution mentioned. But Article 14, not say citizens. So that's why Justice Madden say there is thus no doubt that the high courts in India exercising the jurisdiction Article 26 have the power to issue a writ of mandamus, or writ in the nature of mandamus, or to pass order and give necessary direction, where the government or a public authority has failed to exercise or is wrongly exercised the discretion conferred upon it by statute or a rule or a policy decision of the government, or an exercise such discretion nullified or an irrelevant consideration, or by ignoring the relevant consideration and material, or in such a manner as to frustrate the object of conferring such discretion or the policy or implementing which such discretion has become. All such cases and any other vision of a case, a high court can, in the exercise of jurisdiction, is a writ of mandamus, or a writ in the nature of mandamus, or pass order or to compel the purpose in a proper and lawful manner of the discretion conferred upon the government or the public authority. And in proper case, in order to prevent injustice resulting to the concerned parties, the court may itself pass an order or give directions which the government or the public authority should have passed or given had it properly and lawfully exercised discretion. Very nice judgment, man. Very nice. And purpose these are all high courts of India, not the Supreme Court. This 226 power is very enormous, very wide. But unfortunately, the authority thinks they are out of the law. Nobody is out of the law. Even most powerful man in the relevant time Sri Krishna, he was aware how he will die. Because he can see everything, he can assess everything. But he never avoided that. A small persons, a hunter, kill him. Sri Krishna accepted it. Nobody above the law. Rule of law will prevail everywhere. Maybe a Sri Krishna, doesn't matter. So that's why, my lord, the way they are proceeding is not permissible under the law. Rule of law, certainly, no, you can't do that. This is beyond your capacity, and you're doing the way you are doing is very unfortunate. No law will accept it. So, my lord, this is very relevant for these reasons. Now, regarding adverse positions, before that, I'm interested to, I've placed for you, losses, my lord. AIR 93 Supreme Court 2592. I don't know if it's recorded or not.
2590.
AIA All India Reporter 1993 Supreme Court 2592. জোরে বলি, আমার গলা জোর আছে। It's not there.
It has to be.
It is not there, leave it. I just read one line, I'll just leave it.
Okay.
Because here, in some statement which has not been controverted, what is the consequence of this? Especially in the case, because there's a basic and fundamental difference between read and the plaint. Because the plaint, only facts are there. A lengthy process, my lord. It is still to be filed. And then discovery of document and other things. But then read, my lord, that's why consciously, just earlier case, have a filed your affidavit. It's very vital. If you do not controvert all this by filing affidavit, or even by filing an affidavit, if something is not controverted, what is the effect of that? Supreme Court says, read petition procedure, certain aberrations made in the petition by the petitioner, aberrations not controverted by respondents. High Court should proceed on basis that the aberrament has been admitted by respondent. So, my lord, some statement which has not been denied. Oh, you have not denied. From that, I'll start. Here is the question of any evidence, giving evidence, oral or documentary. Only annexure is given in the writ petitions. Now, the question of adverse positions, my lord. Very lengthy judgment. My lord, recently, my lord,
Yes.
no, my lord, this is Justice Arun Mishra. He used to write a very lengthy judgment. He has a chief justice here, even the Supreme Court, my lord. Are also, the problem is this in open court. Are also, why you are talking or submitting such a lengthy argument? Because he always delivers a lengthy judgment. That is our problem. All right, all right. Once 12 years, because in case of private party, it's 12 years, my lord. In case of government, 30 years. Once 12 years period of adverse possession is over, even owner right reject him is lost, and the possessory owner acquires right, title, interest possessed by the outgoing person's owner, as the case may be, against whom he has prescribed. Once the right, title, interest is acquired, it can be used as a sword by the plaintiff as well as sealed by the defendant. So, my lord, now both can be used by reciprocal with the plaintiff. So that is why, my lord, my right, and they say, award is given, award is taken, very good. Then you have become owner. It cuts both ways. Once you claim that you are owner, your right to protect your property. If I adversely possess more than 30 years, your right is lost. Because adverse possession against the actual owner. You claim yourself the owner. You have no other authority but to accept whatever you have said, that is correct. You can't have both ways. Again, I say I'm grateful because my lord, because with your lordship's experience, nothing wrong. Nothing good or wrong. Because my lord put me these questions. Can you show me any receipt that they have accepted the rent from you? Yes, my lord. And that is a part of the record, which has not been denied. That remain uncontroverted. So the day on which I enter into the possessions and I continue for 30 years, you have accepted the rent and all of things from me, your door is closed. I can use as a sword. No, I will not allow you. It is my property. It is not first time. Even Privy Council, I am not pardoning your lordship with all those things. At that judgment also, Privy Council, there also that question raised. Privy Council says, certainly, you have lost his right. Queens has lost his right. Even the judges are very courageous. Queens has lost his right. Because the person who has come before us, we found from the record, he has been enjoying for more than 30 years and by paying tax, rent, everything. We never made an attempt to evict. And what they did?
Yes.
Because some occupier, some person challenged with the High Court, some occupier, forceful occupier sitting over there, kick them out. That is the cause of action. And person submitted to the Supreme Court, everything is evicted. What remains, my lord? How you can use this type of notice? You can't. Keeping the matter pending and people order passed by Justice N.K. Mitra as well as was, you didn't care and bother. Who cares? I could order, my lord. One should give some minimum respect to the court. Court is not moving with a rifle to implement the order. You, the administration, you will have to obey this. Otherwise, I know how to tackle it. So, my lord, if all those things are taken together, there's no doubt about it. The persons who are opposing me, they don't have any title. It is the government who is acquired. They accelerate everything. Even if it is handed over to the higher authority, they say the purpose for which we need for construction of the side road, that is already there. And not only that, in between some other government land are there. So how can some lands are not vested? That is also there. How can we implement that particular scope as necessary? So entire malafide, my lord, is nothing but an intention. I know, my lord, there are some people who are pulling the string sitting behind the skin. The way some person has been relaxed in their case, the same way they are actually provoking these authorities. Because I know this, my lord, that well, take their land. I need not disturb your lordships any further. Probably, according to my limited knowledge, my lord, I tried to convince your lordships. Now, let us wait. I may lose, I may win, doesn't matter.
Thank you.
Get may I leave.
Yes.
You will also want to ask me.
Yes, I have a query from him because he has argued that some of the lands were released.
No, Your Lordship. I appear for the National Highway Authority in this matter.
State.
Still not that.
Okay.
Madam, he has sworn by the Lord, 894.
They are lucky enough that my lord is giving them a reply against reply.
No, no, not reply against reply. Just since you have argued,
Letter has been issued by the officer and acquisition officer to the executive. Yes, it means split of the land. And my lord, legal to one revolutionary course, from which the petitioners filed the purchase. And this is the letter of the year 1994. And this letter has not been by the court. If it is by the release, then how the capacity?
কি বলছিস বুঝতে পারছি
no, no, no. What he is submitting is that since you say that this land is required Just a minute. Since you say that this land is required for extension of a service road, in between it is intervened by the land of the other plots,
which is not required.
as well as let me complete first. If the query is not put to you, how can you answer this? Don't intervene in between. Now there are certain also plots which is says green, marked green, which is intervened between the road and the plot of the petitioner. That has been released. So his point of argument is how the service road will be completed if that land is released to the other person.
And they are not.
If your contention is,
they are not saying not released.
what happened?
Oh, केव बोलते
Lordship,
पारबे
that
ना.
is
नहीं
not
तू
true.
तो
This
210.
map is
Just a
50
minute.
years old. This is not the present day map. Your Lordship, the present day map is at page 167,
Absolutely.
which is
Kindly send anybody from here. I admit. Kindly send anybody.
Lordship, let
No,
the
very
court
well.
officer be
You have
appointed.
manufactured this plan. You have
We'll
prepared this
decide.
plan according to your convenience. Kindly send anybody from here.
We have no
I am
objection
taking
to
the
that.
risk.
Let a
I am
court
taking
officer
the
be
risk.
appointed.
Yes.
The court officer can visit the premises
Yeah, I don't mind.
and can ascertain whether the land of the petitioner is next to the national highway or not. We have no
I
objection.
don't mind. I don't mind. Kindly come to page 210 of the paper book. They say not released. Kindly come to page 110.
Page 167, plot number 5472. That is, Your Lordship, the CS
Page
number.
210. 210 is
That is
there affidavit.
Absolutely
at bottom.
next to the national highway.
Absolutely wrong. Absolutely wrong. Send anybody in between. My friend, I cannot blame him.
Lordship,
Whatever
page
instruction he has received,
155.
he is handing over. Page 210, my level has got it, my lord.
There's an inquiry
At bottom.
report, Your Lordship.
Page number?
Lordship, may kindly see page number starting from page number 152. This is a letter dated 6.
This is a question of fact, my lord. I am taking the risk.
My learned friend may kindly not interrupt me. I have not interrupted him during his submissions.
You are right.
Page 152, Your Lordship, is a notice issued by the Government of West Bengal, Office of the District Magistrate and Collector, Howrah, dated 16th of June 2017. Kindly refer to the forwarded petition dated so-and-so of so-and-so. The petitioners are found to have alleged that the government lands acquired under LA case number 57, Act 2 of 1962-63, Mouja Kolora under Block Domjur, are being misappropriated by some persons and filling up of water bodies, and they are also found to have urged that the immediate steps to be taken against such persons for misappropriation of government property or land by restraining them from changing the nature and character of government acquired land. It is informed that out of plots mentioned in the petition, plot number 6190, 6163, 6164, these are the plots which are not found to have been acquired. 6265 is not one of them. Under the aforesaid LA cases, the following plots of land measuring 11.59 acres of Mouja Kolora has been acquired by the government by publication under section 41A in the Gazette of India, dated 1st December 1964. Now, Your Lordship,
My plot is completely different. I'll place.
it is.
On that basis, Justice Bhattacharya passed this order. Matter to the Supreme Court. They say everybody is removed. My plot is not within that.
I have dealt with that in my affidavit.
Let us see. Since it is reopened, I don't mind to reply.
So you say that the plots which he has indicated, those plots have not been acquired.
Lordship, plot number 6265. Lordship, may kindly see the list of the plots which have been acquired. That is at page 154.
No, we are not concerned with acquisition. He has raised a point that there, after acquisition, there has been release. So how can he be deprived? He has
Page 210. Sorry.
Particular, Your Lordship, may kindly see the inquiry report at page 155. 6265 has never been released. Your Lordship, may kindly see the chart which is at page 100, starts at page 157. Page 158, plot number 6265, The then owner was Sachirani Kumar at the time of acquisition. Present owner Gangadhar Patel. Present occupier. I shouldn't be saying owner also because he has derived his right in 2002 and 2007. That is post acquisition. So as such, the entire deed of conveyance is a nullity.
No, just I want to know that there you have this map with you.
Yes, I've given.
Also, this chart is
Chart
contrary
or
to
chart,
five.
the map.
Forget
The map
about
is
this.
contrary to
Forget
our
about
map and page
forget
106.
about this. Is there any plot of land which was under acquisition has been released after the acquisition has been completed?
No, Your
Kindly,
No.
kindly take all page 210. They are not affiliated.
210.
My lord,
210.
210. That was 210. At bottom. Because at any stage, if it is a scheme was from earlier, notification. Have you got it right at bottom? 210. It may further be submitted that originally an area of such and such acres land in Moujak, New Kolkata was proposed for acquisition for the project and acquisition position was taken accordingly. Can you mark it, my lord?
Okay, I've understood.
And then next page. Subsequently, an area of such and such from the project and for purpose of acquisition of such. They have admitted.
excluded from the project does not mean that the land has been released.
Subsequent in area of extra point. Yes, take that.
Your Lordship, we as the National Highway Authority have
Okay.
submitted that we have carried out this action.
So as per you, it was excluded subsequent.
Section 26 notice we have issued as per the direction of this Honorable Court.
I'm grateful. Thanks to my father,
See.
my friend, which was absolutely just diluted because they themselves appear and say all land has already possession been taken up all lands. Matter is there. How can you?
Okay.
And Your Lordship, with respect to
Awesome.
this, Your Lordship,
For 81 will be extended till the charge.
Heard Mr. Ashok Kumar Banerjee,
Get
learned senior advocate, appearing for the petitioner who concludes his replies. The hearing is concluded. The judgment is reserved and made CMA. The interim order is extended till the delivery of the judgment.
That's it. Now may I leave my job?
Yes, thank you. Thank you all. Thank you, Mr. Bond. Oh, sorry about origins.
Tendering, I'm tendering unconditional apology, my lord, for saying this, my lord. May I be permitted to say something, my lord? Yesterday I have mentioned this matter. Lordship has said that to serve the opposite party and to come, my lord. I have done that. Learned senior advocate Chandi Charan has received, my lord. I have the copy, my lord. My lord, kindly I give the for hearing, my lord. Yeah, yeah, lord.
Original side.
May I be permitted to hand over it?
No.
Original
Mentioning
side.
time
Next
got-
side. Lordship, next item in appellate side is my lord item 6. Actually, 12:30 is the time for original side. My lord, may Lordship kindly fix a date, my lord, because there was a directioner filing reply. Yesterday night at 9:15, he has sent me online. Soft copy, hard copy not yet, despite the peremptory direction of your Lordship on the last order. So, my lord,
that is regarding that encroachment.
Lordship. So may a date be fixed, because since my lord, he is trying to, I don't know why this practice is adopting in this court, I don't know.
But he was there in his office is there. Why you are not giving the hard copy of so that he can respond
No,
to that?
on 6th January was peremptory direction, 6th January. Last Monday, Lordship was pleased, okay, I am giving you a judicial grace, extending the time, despite your Lordship direction was peremptory on 6th January. Last Monday, Lordship has been pleased to show him the judicial grace. That was last Monday what was the date? 13th January. And yesterday night, that is 16th January, yesterday night at 9:15 in the night, he's sending online copy to my learned.
Lordship,
Today, I don't know whether he has come with a ready copy of hard
Lordship,
copy.
our client is
Whatever
residing
may
at
be.
Siliguri and the affirmation made
It's a
on
matter of
made on in
2023,
the afternoon. Then
2013. It's a matter of 2013.
Now it is ready.
yes, Lordship, I am filing.
When you have affirmed the reply,
Yesterday at about 4:35 p.m.
Would have easily served us. We are here in the court corridor till 5:30.
এই item number?
Lordship, item 6,
number
next
6.
item.
ওইটা order করে দিন। কোথায় গেল?
Lordship,
আছে?
please to fix a date. I want
Lordship,
the hearing to be
kindly
done by
fix
your
a date.
lordship.
কি হলো অফিসার সব চলে যাচ্ছে কেন? কোথায় গেল ওরা? এখনো শেষ করিনি অ্যাপলেট সাইডের। এই ডিকটেশন কে নেবে? না ও নেবে কি করে? আবার হ্যাঁ? What was the timeline for filing the reply?
Below on 6th January 2025, it was peremptory.
6 January, what was in 1 week?
It was that he has to on the prayer release the matter on so and so.
হ্যাঁ,
On 13th January was a returnable date.
আচ্ছা।
In the meantime, reply not given.
13
Matter came
January.
up on Milord Monday.
Extend the time, accept the reply, give a copy.
Lordship, may please to fix a date. I want the matter to be heard before your lordship.
Determination is changing. ওটা কি স্পেশালি আছে না?
No, on the last occasion, my learned junior
Anyway,
told me that he is
বলে
taking
দাও
a
হালকা
point of
করে।
circuit bench, this, that, lordship.
আমাদের ডিটেনশনটা সোমবার থেকে চেঞ্জ হয়ে যাচ্ছে।
Now we have received one modified, lordship.
Changing.
They are trying to avoid.
What to do?
Because Monday, my learned junior was present, I was not. He was taking a plea. It's a matter of circuit bench, my lord. Why hearing over here?
Ah,
this
yes,
and
yes,
that.
yes, yes. Yes.
So now he has
You
succeeded.
should know the rules now. I have to take out the rules and find out that prior to 2019.
He has succeeded in his ploy now. His entire ploy was to avoid this court. Lordship was pleased to hear me, my lord. Kindly have a look on 6th January. My entire submission was complete almost.
Oh, now I cannot take reply. I have to reply.
I will
I'm
not,
taking-
Lord.
Yes, that is the difficulty. কোথায় এসছে? বলে দেবেন? আচ্ছা। item number, appellate side লিখে রাখুন। Item number 6, Mr. Mohammad Ghalib, senior government advocate, appearing for the state respondents, indicates that yesterday the copy of the reply has been sent to the learned advocate, junior advocate, through online
At 9:15.
at 9:15
At
p.m.
9:14.
9:14 p.m. The hard copy was not served upon him. Mr. So-and-so learned advocate appearing for the petitioner submits that the affidavit in reply was affirmed when time
5 p.m.
now 4:30 becomes 5 p.m. at 4:30 p.m. yesterday. Achha. He seeks extension of time to file the affidavit in reply. 6 leave for the leave granted, affidavit in reply filed on behalf of the petitioner is taken on record, copy served.
He has not yet been received.
Is this matter?
7 একটা
There are two replies, my lord.
Reply to কোথায় নিন তো? Two replies against which opposition?
Replies. Because we had two oppositions.
for respondent number 7 and for respondent number 8.
Both are represented by the state.
Lordship.
One is police officer in charge, other is the BLR.
Lordship.
Is this matter
Lordship
wrong?
has commendable mem.
Who?
No, already recorded. Why receipt?
হ্যাঁ। আচ্ছা। একটা তো ডেট দিয়ে রেখে তো কি আছে? Please this matter after 2 weeks. হ্যাঁ, ওরা মেনশন করবে ওখানে গিয়ে লিস্ট করে নেবে। আজকে তো আছে, আজকে তো দিতেই পারি না।
Lordship, kindly record. I am giving a hard copy to upon the.
Copy, sir.
Recorded.
When you file,
এটা একটু
this
kindly
original we kept.
হ্যাঁ, yes. ও এসে গেছে? এই এটা নিয়ে নাও, হার্ড কপিটা নিয়ে নাও। চলো। No. Sorry, sir.
Great.
Now I have to take up your answer.
Let me-
No.
Item 14, my lord, demolition order is my lord.
Only we'll see.
My lord,
Now we have to take up the original side matter.
my lord, item
Sorry.
14, my lord, demolition order is
Oh.
there, my lord. My lord, kindly allow me 27, my lord. There is a
Madam, I have to
order,
take
my
up
lord.
original side matter.
My lord,
No.
kindly protect me for some time, my lord,
No.
because my lord, appeal court has directed the lordship to take into account the consider the
Okay,
point, my lord.
Right,
But
your lord, before the other bench
take
now,
27, my lord,
madam, the
kindly.
determination is being changed from Monday.
I do understand, my lord.
And
but
I
the
will take
lordship
up original side matters 12:30 already. Please don't argue. 12:37, I will take up the
No,
original
says
side matter.
it is demolition
Yeah,
order,
okay,
my lord.
okay.
I protect till
No.
27, but thereafter, my lord,
Down,
whatever
call the list, call the list,
my lordship
call the list.
candidates.
Non-contentious PLA.
Certain errors.
এই দেখো determination কি আমার এলো নাকি 2009 Oh.
There were certain departmental corrections that were required to be done.
Okay.
This has not been complied with, just for inclusion, lordship.
But-
Great, lordship. Mention one general applications. My lord, I am praying for general application. Number 18 of 1963. Applications. We have prayed for shares of funds. And there was a special officer, 2 applications are pending, my lord. I am today only seeking the interest of the 2 applications. My lord, kindly takes up the matter any day subject to your lordship kindly.
Already special officer has been appointed, my lord, and direction over the special officer has already been done for distribution of the
My lord,
fund.
kindly takes up the matter any day under the heading to be mentioned. I shall appraise your lordship.
Mentioned February to up.
My lord, kindly fix it then after, my lord, 26, 27 thereafter.
In the month of February, this will be listed.
Group 1 हट गया है, Group 5 आ
Down.
गया। आप left side का portion
Original side daily list item number 1.
5 ऐड हुआ है।
GA 35 of 2022 and GA 41 of 2023. Both the applications are dismissed. 3/4 টা টেকে দিন এটা।
Item number 3 and 4.
Milord, only
Three.
thing, Milord, we shall go through, Milord, your lordship charge. Milord, only thing is, Milord, so far their application is concerned. Milord, can you get a copy?
No, no,
Because
that
now-
is the
now-
issue, my lord. Your lordship said
Yes,
depending on
that is what that is appearing under for directions. So let us see.
Your lordship had observed that if they succeed, they shall give. But not our contention is that today, as of now, they have no right. The moment your lordship directs, we shall bring out all, but they can participate in the proceedings, everything.
Milord, we will not get a,
I just want to know the other applications which was disposed of for appointment of a special officer for holding elections at that point of time, whether the copies of the application.
I'll be very candid. We did not serve anybody.
Ah.
No, please let me finish my submissions. I have a duty to the court. But there were some people who had appeared, and at that point of time, the learned judge did direct. So
Okay.
some people did appear. But I will not never mislead the court. But not for any direction. But if anybody had any view, no copies, they came up and expressed their points as far as the election. No copy was ever served on anybody, but
They were allowed to make their submissions.
yes, whatever objections they were heard.
But then any notice was affixed in the office of the estate.
When once the election is declared,
No, not election declared. Before hearing this application for
no, once this order is passed, this order is thereafter. In any case, at the time of passing of the order also, the learned judge had heard objection from others.
okay.
That I have to be cognizant that because I'll never say a word which is
But
not
Mr. Banerjee, without notice, how can the person come up before the court and
No, some people had come on their own, like my learned friends are here. So
Okay.
they came and has said that we have this objection, that objection. So the learned judge considered some of their prayers, but what happened was, very frankly, on the last occasion, the court, after hearing objections of various persons, said that the liberty was given to the chairman to frame rules and regulations for conducting of the election. So they were told, you go before the chairman, who the court appointed. So they had a right of audience over there and they could come and give their suggestions.
Last time also, my lord, the report which was accepted, that was also taken into consideration. All the points taken and the majority view was taken in. And a lot of new additional points were added in the last year's meeting also, because of various objections and points taken at the meeting. So this was how it was conducted. But nobody as such was served upon it.
My lord, may I? My lord, Lordship, kindly consider this. My lord, according to my learned friend's submission, and that is also reflected from the record, that my lord, there were certain branches or certain, my lord, persons, my lord, who claims themselves to be, my lord, the Sevites, my lord, they were served. And my lord,
They were allowed to make their submissions or oppositions.
Yes.
my lord,
Submission.
today, my lord, considering this, my lord, there are other parties apart from us also who may be interested. My lord, as it has fallen from your lordship, my lord, there has to have that is the very basic thing, my lord, we are propagating, my lord, before the courts, my lord, from the very beginning, that, my lord, everybody should be notified what is happening, at least minimum, so that even before an order is passed, anybody who is having a say in the matter, my lord, can come, not, my lord, before the, my lord, person, my lord, who has been nominated by your lordship as an election officer. There, my lord, the purpose is limited. There may be other aspects also, my lord, who can. But why there won't be a notice? Why there is a pick and choose? But today I have taken a, my lord, step, my lord, I have come before your lordship, my lord, there are other parties also who may be interested. They do not know even that what is happening in the court with regard to the estate. My lord, that one aspect. And what is the harm if I go through the petition, what is there, and we can make our submissions? Well, there is nothing hide and seek. My lord, to the extent possible, my lord, the documents, those are available with us. We already have, my lord, ventilated our grievances and, my lord, our views. My lord has been pleased to consider there was no harm. My lord, what is the harm in serving a copy of the application that is going to be? Because, my lord, we are here. I have not said, without going through the application, that direct, my lord, to file a affidavit in opposition or something like that. It may so happen, my lord, going through the petition, I may not submit anything. But I need to know what is there at least. That, my lord, right of audience cannot be shut up.
May I make a answer to this? All I have sought for, I have not asked for any decision to be taken by this court, except for appointment of a chairman who will go into the secretariat. But today, why this prayer is being made for service of copy? Because of the simple reason is that today one party will come in. After this service is effected, another party will come in. So like that, you know, there are hundreds of Shevites. This whole thing is to stall the proceedings so that because it has to be done 3 months. By March, the entire process has to start. So this way, this entire process will be stalled. But on the other hand, if your lordship, while going through the application also see, your lordship, there is no allegation against anybody. For anybody to respond, there is no allegation. It is only that here is this matter, this trust is there, this trust has to be administered, this trust administration has to be done by a body of Shevites. So they have to be elected. So appoint somebody who will conduct the election process, and your lordship will also direct that he will hear everybody, because hundreds of people, he will hear everybody. So instead of your lordship hearing everybody, because it is actually physically very difficult, because for your lordship to, because every second day somebody will come up with another application. That is the reason, my lord, why your lordship directs the chairman, whoever, my lord, last year, my lord, former Chief Justice of Calcutta High Court conducted, and my lord, phenomenally it was conducted. I have heard the entire thing, and he conducted everything. So he hears everybody. A large number of Shevites whose rights were due, Lord, he has adjudicated in their favor. I am not, Lord, standing in the way of anything. But over here, the process has to begin. Today, all we are asking for before your lordship is for the process to begin. If your lordship directs service upon one party, thereafter, every 15 days, there will be one other party coming in and saying, give me service. So the whole, this holding of meeting will keep getting postponed to ensure everybody else. Now, if your lordship allows one, your lordship will have to allow everybody else. But my lord, they will all have a right. It is not that any of the decisions will be taken without them. They will all have a right.
Lordship, kindly,
every point.
My lord, the anticipation, my lord, what my learned friend has expressed, my lordship kindly consider this, my lord, it's after all, my lord, before your lordship, my lord, it's a public document.
Hmm.
My lord, anybody can obtain a certified copy. Well, I do not know, my lord, on what basis. Well, today, suppose, my lord, this is declined, that my lord, the copy is not served. My
No,
lord, are we
I'm
debarred from
thinking of
getting a
the
certificate?
other way.
Yes.
If suppose an application
Yes.
for administration or holding an election is not filed in court, but the estate is monitored by the High Court.
My lord.
So responsibility lies with the court for holding the election within a particular period.
Absolutely. Grateful to you.
Because there is a scheme which is existence. So even if an application does not come, but it
Lord,
comes to the notice of the
scheme-
court that
scheme,
election
my
is
lord,
due.
With due respect to my lord, what has fallen from your lordship, my lord, the scheme, my
Since-
lord, is saying,
Since the
my lord,
process
is
Mr. Ghosh,
non-existent.
since the process is adopted by this court,
Yes,
the
process.
matter is relegated to the special officer to call for the objections and meet out the objections and they dispose of.
My lord,
As far as you are concerned or your client is concerned, since you are in the proceedings, so I fix a date for hearing of that application. If you have got any objection orally, you make your submissions. I will record that and thereafter pass on. That will because
as
matter
it
is
proceeds.
after all the matter will be relegated to the officer. As you say, that process will follow.
It's not that not anybody would be shut out.
42 তে করুন।
Yes. And the first thing that happens is not publication of the notice for everybody to come.
42 এই 5 তারিখে ফিক্স করো 5th 42 and 43 5th শুনবো অন্য কিছু রাখবে না 5th
Could it be on Monday, Miller?
I'll be in Jalpaiguri.
Oh, sorry. I'm
So
sorry.
after I come back after the Saraswati Puja, on the 5th, I am fixing it. Mr. Ghosh, when the election is scheduled to come up in the month of April or May?
It should be, my lord, in the month of March itself.
March. Okay.
If that 3-year duration, my lord, we take into
It
consideration.
has to happen in March. June.
June.
জুনেতে মার্চের মধ্যে প্রসেসটা আরম্ভ
Yes, it has to.
The
That's
process
okay.
will start right.
That's what I'm saying.
7th দেখো 7th 5th is 7th 6th দেখো 6th
Be 10th, my advocate would not be here.
because I want to start with this hearing because other matters will not be taken after you conclude your submissions and then you dispose of this application because since you indicate that March has to start, so from March 10th 10th এ দেখো 10th monthly list 9th 11th দেখো 11th Mr. Ghosh 42 this is an application for appointment of chairman cum special officer to conduct election of 3 trustees for the new board of trustees and also for determination of the voting rights of the years of the Sebayats who have expired since the last meeting held on 24th April 2022 before conducting the election and other allied prayers. Mr. Amitesh Banerjee, learned senior advocate, appearing for the applicant, submits that the process of conducting election is to begin from March 2025. He seeks that a date be fixed for hearing of the application.
Thank
you. Mr. Sudeep Ghosh, learned advocate, you are one of the Sebayats, Mr.
Well.
For one of the Sebayats, submits that the copy of the application be served upon him. In reply, Mr. Banerjee, learned senior advocate for the applicant, submits that This is a formal application for holding elections and there are no such allegations against any of the parties. However, liberty be granted for Mr. Ghosh's client to make his submissions before the court. In view of the above, list this matter on 11th February. Liberty is granted to Mr. Ghosh to make his submissions on the date of hearing. What is 43?
My lord, this is my application, my lord, one of the Sebayat, my lord. Because I have taken the, I have
43 টা দিন তো।
Only thing, my lord, since you lord will not take it, but Mr. Ghosh is appearing for which Shebayat, if my lord, it is indicated, my lord, the name of the Shebayat.
Yes.
Bikramjit. Lord Bikramjit Das.
বিক্রমজিৎ দাস ওই যে বলুন ওয়ান অফ দি সেবায়স ওপরে
By
ওটা বিক্রমজিৎ
We don't have any problem with that.
that will not on instruction of my learned advocate.
No, obviously, obviously
Bikramjit
nobody will say that
Das.
he'll appear on his own. I have nothing to say as far as the Ghosh is
My lord,
concerned.
in this matter, my lord, I have prayed for, my lord, there is a PIL is pending before before the division bench. And my lord, the question of mentality to stay with, to stay the proceedings, my lord, there is a one prayer. And other prayer is whether the mentality of the case itself, when the suit has been abated, our 1 point as a private matter trust, or if then it is not maintainable, the other order is concerned. But if the suit is the matter of the public matter, the trust, then the government should intervene in the matter. So, my lord, these are the 2 points I have taken in the
all consent
in this application, my lord. And my lord, in the meantime, lordship pass the judgment, and by going through that, I will argue on the next occasion. It says there is a matter is pending before the London division bench.
This has
Case
been
number
given to
is
you. This copy has been served.
Yes, that has been served.
Okay.
Whether suit is at all maintainable.
43 তে head করুন list this matter. Let this matter appear on 11th. You will be filing any opposition to this? Let yes.
Must to file. If you say let that be in 11th,
Let it
because
appear on 11th.
this appear to
In the meantime.
but if this could appear on 13th of February.
13th. Why?
And we shall file up with because 11th my advocate record will not be here. I will
11th because 42 is appearing on 11th.
Yes.
Oh, very good.
Well, let it be on 11th.
Oh, 11th.
In the meantime, affidavit may file exchanged.
What you do is in the meantime, if you intend to file opposition, you file that. Let it appear on 11th. He also gets a 1 week time to file reply, and 11th it will appear. তাহলে করে নিন। Let the affidavit in opposition be filed within a period of 10 days. Reply there to be filed within a week. List this matter on 11th. 43 তে করবেন এটা। ওইটা জাজমেন্টটা না এই জাজমেন্টের চেম্বারে পাঠিয়ে দাও।
আসছে 11 তারিখে আসছে ম্যাডাম।
Okay.
Can you go through the order of your lordship?
Afterwards, it will be uploaded in the course of the day.
Item 5, my lord.
Item number 5.
Correction of my lord cost.
This matter is appearing under the heading to be mentioned mediation. Cost title.
In the list, the cost title is appearing today. That is to be incorporated in that order. My lord, the order dated not 6th December 2020. Only that.
Inadvertent typographical error has crept into order dated 6th December 2024 in the cost title. In the cost title, sorry, the order is modified to the extent in the cost title in place of Shambhu Ghosh, inverted comma. It should be Shambhu Ghosh versus Mrs. Carewell Properties and others. এখান থেকে দেখে নেবেন এই যে এটা এই পার্টিটা লেখা নেই এখানে, হ্যাঁ? Shambhu Ghosh versus this. The other portions of the order is modified to the above extent, the other portions shall remain unaltered. Yes.
And this is to be incorporated in that order.
The modification be incorporated in order dated 6 December 2020.
I'm great. আজকের মধ্যে হয়ে যাবে সবার।
Very.
Witness action item number 6.
I appear for the plaintiff. My lord, Mr. Rupak Ghosh is appearing online. Kindly permits him to join, my lord.
Whose witness?
My witness.
The bank's witness, my lord.
Defendant number 3, madam.
I will cross-examine the witness.
My lord, we are on chief. We will tender the documents, judge's brief on documents which has been disclosed. May I? There are around.
You will now begin with the defendant's witness, or?
Yes. Now.
Where is he?
Also, my lord, kindly permits Mr. Ghosh to join, please.
You cannot cross-examine the witness through online.
No, my lord, perhaps today
even the tendering may not be completed.
Yes.
Okay.
Because there are 50 odd documents are there. May I just
You start. Yeah.
start?
Only so that, my lord, if any objections, my lord, needs to be taken, my lord, that can be done.
Speak in English? Yeah. Yes, बोलिएगा, ठीक है? Yes,
देखो उन्हें देखा जाच्छे ना अभी? He has not joined.
मैं जो
Yes,
बोल रहा
my
हूँ
lord,
मेरे
he's
साथ
here.
repeat कीजिए. I solemnly affirm whatever I depose by the way of evidence, I shall speak truth. No part of it shall be false, and I shall not conceal anything. Your name? Chiranjit Mishra. Your father's name? Prabhat Kumar Mishra. Your age? 39. Your occupation?
Chief Manager at Bank of Baroda.
Chief Manager at Bank of Baroda. Your residential address?
Panas House 5, flat number 1B.
Spelling?
PANACHE. 03 Mohis Batan.
Mohish Bathan.
MAHISBATHAN. Todd Lake. 7001.
Speak slowly, they will like, okay?
আস্তে আস্তে
আস্তে আস্তে বলবেন, যতটা পারবেন আস্তে আস্তে বলবেন, হ্যাঁ? ঠিক আছে? আচ্ছা।
My lord, I am appearing online on behalf of the plaintiff.
Yes.
Kindly allow me to appear online. Continue to appear online.
Okay.
Mr. Mishra, you have come here to depose on behalf of Bank of Baroda, defendant number 3 in this matter. Do you have any letter of authority issued on behalf of the bank?
Yes.
Can you produce that letter before my lord?
What is his rank, you tell?
The copy of the letter, my lord, we don't.
This is itself a copy. Where is the original?
What is the original thing?
His rank is here, sir. Still.
তাহলে কোনো objection থাকলেও একসাথে দিয়ে দিতে
ঠিক এই নিন এই দেখো এই দেবাঞ্জন What is his rank?
My lord.
He is in Bank of Baroda in which post?
Chief Manager, Scale
Chief
4.
He said that chief manager of Bank of Baroda.
Okay.
He is also the branch head of the Charu Market branch that is written in the letter of authority.
Okay.
Which branch is concerned in this matter? But may I now tender DD1 defendant's document, which is part of the judge's brief of document at page 1 and 2.
So,
Yes, this
additional বললো That.
no, this is judge's brief of documents containing documents. There's a composite judge's brief of document, my lord, plaintiffs and defendants, my lord.
Yes.
Prepared by my learned friend. These documents have been admitted. There is no objections raised in this matter. Only the exhibits to be marked. Formal tender has to be done.
This is DD1.
DD1, my lord.
Mr. Shengupta, please check whether we have admitted all these documents.
Mr. Mishra, kindly look at the document and tell my lord what is this document about.
It's a signature card for account 2971, which is executed by Subhodra Saha and Shankar Lal Saha as per name.
Subhodra Saha and Shankar Lal Saha. প্রশ্নটা গেল
It is dated 11/3/1994.
Let it be marked. Exhibit.
1 থেকে শুরু হবে মনে হয় 1 থেকে হবে 1 হবে মনে হয় ডিপেন্ডেন্টটা প্রথম তো আগেরটা কিছু মার্ক হয়নি তো আগেরটা
That is one side. This is the original.
তুই আবার কোথা থেকে
এটা 1 2 হবে হ্যাঁ
কোথা থেকে এক্সামিনেশনটা
And let that letter of authority be also marked so that it can.
My lord, authority subject to objection, my lord.
বললো বিগিন করেছে
Original letter of authority.
because this defense witness was commenced before other bench.
No, this first time, my lord.
This is the first time the witness of the examination is going on.
Section of defendant number 3 has
কি বার করেছে ওটা কমপ্লিট হয়ে গেছে
May I indicate, my
নামটা
lord?
কি
There is
আছে
a commissioner's report, my lord. Plaintiff's witness was closed. The commissioner's report is there, my lord.
দেখো দেখো আমাকে ওটা দেখাও তো তুমি যেটা দেখালে আমাকে DW1 সার্টিফিকেট ওনাকে দেখাও এটা হু ইজ রত্না সরকার
DW1.
DW1.
DW1 exhibit 1 has been marked. So today if DW2 starts, it will be
DW3.
DW3.
DW2 is in expertise.
I am talking about the marking of the documents.
Yes.
Today the documents will start from 2.
ওটা already exhibit mark করা আছে আগে
2 থেকে শুরু
Can be.
But subject to correction, it would be a different series altogether from DW1.
Defendant's witness number 3.
It will for this witness it will start as 1.
Not one, my lord. It should be, my lord, say A1 or D11, something like that. D21, something like that. It would be D21 if I am not wrong, my lord.
No, no,
Or D2A.
no, no. Plaintiff's witness is marked as A, B, C, D.
Yes, my lord. So it will be D21 or D22 like that.
দেখুন তো exhibit 1 করেছে।
Or alpha 1, alpha 2, whichever, my lord.
The judges,
Okay, okay.
judges in the judges brief of document, it has been marked PD1, PD2, PD3.
Okay, okay, ঠিক।
And it
তাহলে
has been
D3 1.
marked in judges brief DT1.
হুম।
It's been marked in this manner, my lord.
Authority letter of authority D31.
D31.
Subject to objection, my lord.
Why?
How they have derived the person.
Letter of
giving
authority টা
How they have
D3
derived authority, my lord, that is not mentioned.
Letter of authority has been marked as D3
Deposition
by
with
what?
objection করে দাও। With objection.
With objection হবে, হ্যাঁ?
Deposition এ তাই করো। Yes.
D3 by 2 হবে, তাই লেটার D3 by 2।
কত হলো? কত হ্যাঁ করে দিচ্ছি। কত হলো এটা?
এটা D3 by 2। Signature card has been marked as D3 by 2.
We look at the document marked as DD2 in the judge's brief of documents. Tell my lord, what is this document?
It's also a signature card for account number 7592, which is signed by Subhodra Saha, dated 18/3/95. And Sonkolal Saha also has mentioned.
Sonkolal Saha also. D3 by 3 হবে, তাই তো?
Let it be marked at D3 by 3.
Signature card of Subhodra Saha has been marked as D3 by 3.
Kindly look at this document. In DD3, the judge's brief of documents.
Also signature card for account number 75393, which is dated 18/3/95, signed across by Subhodra Saha and Sonkolal Saha.
এটা অ্যাকাউন্ট নাম্বারটা, তাই তো? এক্সিবিট হবে?
হ্যাঁ,
D3 by 4.
সবই
The signature card being account number 7593 has been marked as exhibit D3 by 4.
Kindly look at this document being DD4 of the judge's brief of documents and tell my lord, what is this document about?
It's a certified true copy of an FD received from Sankar Lal Saha.
Of a FD received?
FD received. Certified true copy. Sankar Lal Saha for rupees 1,50,000 only. This is dated 9th of June 95. FD receipt number is 047673. 73.
এটা দিন।
গেছে এটা লাস্টে গেল গেছে
এটা নাম্বার এক্সিবিট হবে?
D3
D3 by 5 হবে মনে। The document has been marked as D3 by 5.
And we look at this document. It's being filed in the judge's book of documents. And tell my lord, what is this document?
This is also certified true copy of FD number 047674 in the name of Sonkol Lal Saha for 1,50,000 dated 9th of June 95.
Let it be also marked D3 by 6.
The same has been marked as D3 by 6.
Kindly look at this document being D6 of the judge's report. Tell my lord, what is this document?
Certified true copy of FDR 047675 in the name 047675 dated 9th of June 95 in the name of Subhadra Saha for rupees 2 lakh.
D3 by 7. Exhibit D3 by 7. Huh?
Next.
Subsequently, a new paper book was prepared compiling the plaintiff's document and the defendant's document. Then, my lord, that may be looked into so that we will be in addendum of. I think subsequent.
What is the difficulty?
I don't know. The page numbers may.
We're in page 13.
Yes, ma'am. Now, the
Page
draft
11, 12.
document which has been marked.
Now page 13 will be taken up.
Now 13.
DD7.
Very, very. This is the document being GD7 of the judge's paper document. And my lord, what is this document?
Is certified copy of signature card for account number 7831. This is dated 17th October 95 of Basop Kumar Sarkar.
Yes.
It will be marked as
7.
3 by 8.
7, 8. 7 holo 8 হবে না?
D3 by 8. And look at this document. Marked as DD8 in the judge's brief of document is serial number 21 of the index, my lord. At page 28. Tell my lord, what is this document about?
This check number is 005487 dated 5th of June 95. Payee is Shankar Lal Saha for 50 lakhs. It's an original check.
This is the original check. স্যার এটা মার্ক হবে তো? হ্যাঁ আচ্ছা।
Check number to. Have you stated the check number?
Check number he has said.
Drawn on which bank বলেছে? Drawn on bank? Roy Bank কি আছে? Drawn on
Joint Bank, Bank of Baroda.
Roy Bank is Bank of Baroda.
And date of the check?
5th of June 1995.
Exhibit D3 by 9, huh?
Really?
My lord, will stop.
Only thing, my lord, may it be because since he's already in the box, if some time can be allotted, my lord, subject to your lordship's convenience.
মিস্টার নামটা কি বলেছেন? Chiranjit Misra, Chief Manager, Bank of Baroda, is examined as DW3 in part. He proves documents which have been marked as exhibits D কত থেকে কত করলো না DD নয় D31 by D39
D3/9, madam.
D3/9 Is this matter for further examination of the witness. 13th February. Huh? Witness.
Will it be your lordship's pleasure, my lord, to allot a time to it, my lord, since he's
কখন
already
আছে 13th second হবে আছে তো? কি বললাম 13th February. Witness Mr. Chiranjit Misra is directed to remain present on the returnable date. Okay.
Gratefully.
Thank you, my lord.
Yes. Yes. Okay.
Obliged, sir.
Those are already for filing of the reports. Enabling lordship's pleasure, madam, all those two matters, the next two matters, madam, 7 and 8.
Hello, 7, 8, and 9 are similar
7,
matters,
8,
my
he is the special officer.
Yes, well, I was a special officer, my lord. All has been order has been complied. I only have to, my lord, file the report that my lord can be complied.
The application can also be disposed of, my lord.
7 এ করুন না দুটো সব আলাদা 7 আর 8 এ মিস্টার সেনগুপ্ত আছে 7 and 8 you are the special officer. Mr.
7, 8, and 9.
9 he is not there. 9 will take up later on. Go.
Item number 7 and 8.
একসাথে করলে হয় ভুলিয়ে যাবে 7 এটা তো Mr.
Order, my lord, is as well at page 5, my lord. I was directed, my lord, to
submit a report after completion and execution of
my lord, the execution, my lord, and as well as, my lord, the registration has been complete, my lord. The deed is, my lord, annexed.
Okay. Mr. Saurabh Sengupta, learned special officer, files report in compliance to order dated 2nd December 2024. He submits that in terms of the aforesaid order, the process of execution and registration of the deed of conveyance has been completed. In view of he files report order taken on record. In view of the above, the GA being 102 of 2024 stands disposed of. Same order in 8. 8 also same.
Let a copy of the report be handed over to us.
ওটা সেম অর্ডার হবে ও তো হয়ে গেছে সেম অর্ডার করি কিন্তু এটা কত 102 ছিল আর এখানে হচ্ছে 103 ইয়েস আর কি বাকি থাকবে
My lord, item number 9 is also similar, my lord.
In my report is ready, my lord. Only thing is that I have not stamped and punched it, my lord. Otherwise, my lord, in the earlier report, my lord, we used to file it in the sealed envelope, my lord, proper format. Your lordship.
কি আছে করেনি যেটা কি করে
রিপোর্টে তো পাঞ্চিং লাগে না
বলুন দেখি it has been completed.
I have completed the process. Everything is completed.
Oh. Mr. So-and-so, learned advocate, learned special officer, files report, which is taken on record. He submits that in terms of, which was the last order was, in terms of the previous order dated
17th of December. No, no, 19th. Sorry,
19th December 2024. The registration and execution of the deed of conveyance has been completed. In view of such a way, same. GA disposed of. এই এটা দেখুন তো, এটা যেটা সাক্ষী হলো ওটার মনে হয়। এই নিন।
My lord, before my lord rises one of the last item in the list, that's item 10. That's an application for only substitution. I was only praying, my lord, if I could serve a notice upon the proposed plaintiffs, my lord. If my lord
Proposed
plaintiffs, the sole plaintiff has died. There are 3 proposed plaintiffs. I am one of the proposed plaintiffs. The other legal is if I could only serve a notice on them because they've not.
Any order was passed in this?
No, this is first time, my lord. This is coming up
You
for
are
the first
first?
time. Defend.
Item number 10.
Been served.
I have been served.
Mr. Shaunak Mukherjee, learned advocate appearing for the applicant, one of the proposed plaintiff, seeks to serve the copy of the application upon the other legal heirs.
In terms of prayer F, I prayed for that prayer F of the master summons. 3 other legal heirs, I would like to serve a copy and come.
Prayer A.
Prayer F, my lord. F.
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 In view of such submissions, let there be order in terms of prayer F. F of the master summons.
Will you kindly fix a date?
List this matter. After 2 weeks, learned
But I filed
advocate
an
for the
affidavit of
applicant is directed to file affidavit of service on the returnable date. Ready. এটা থাকলো।